It's AM 650's The Law Show, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, good morning and welcome to The Law Show here on AM 650. Our guests in studio are from the Vancouver and Langley offices of Lindsay Kenny, LLP. 3 guests in studio. It's a panel, and I love it. Angela Thiel is a partner with Lindsay Kenny in the Vancouver office. Christine Eilers is an associate with Lindsay Kenny, also in the Vancouver office. And joining us, a return visit, too, from the Langley office of Lindsay Kenny, is Puneet Kara. Hello to all 3 of you. Puneet, nice to see you again.
Lovely seeing you again, too.
We're going to talk about going to court and all that involves. And for most of us mere civilians, that's pretty scary stuff. But before we do, tell us a little bit about, well, we'll talk about the firm. And Puneet, let's start with you. You are a multilingual person in the Langley offices of Lindsay Kenny. How long have you been with the firm?
Since about October of 2009, so about 5 years. 4 to 5 years.
Okay, and your multilingual capabilities.
She can't add.
That's okay. You got a law degree, a little light on the math department. Tell us about the languages you speak, please.
Oh, I speak Hindi, Punjabi, Urdu, and of course English.
Okay. And how many clients do you speak? I mean, this is a tremendous advantage, especially in that part of the Lower Mainland.
Yes.
How many clients do you deal with routinely who don't speak English, who prefer to speak to you in one of those other languages that they're more comfortable in?
Yeah, and that's the right word, preference. So it's not that they cannot speak English,
right.
but most of the times they have that, because it's family law is so emotional that to have that connection with your lawyer, it's sometimes language becomes a barrier.
Sure.
And I think I can really help. But in terms of my clientele, so I would say about 40 to 50% would be, people with languages that I can assist them with.
All right.
Other than English, yeah.
Well, it's a lovely skill to have in addition to all of the legal advice you pass along. To be able to do that in multiple languages it's an advantage for you, and I'm sure the firm is pretty pleased with it too.
I hope so.
Well, yeah. Christine, now you're downtown in the Vancouver office down there on Georgia Street. You've been with the firm for how many years now?
About 3.5.
Okay.
And I only speak English.
Well, that's just fine. You do such a good job with that,
thank you.
though. It's always nice to have you come to visit us. Family law is the primary focus of your practice, but as you grow into the law, you're expanding your areas of activity, and yet you were drawn to the law in the first place because you wanted to become a family lawyer.
I was. I'm one of the few that actually was interested in family law before law school. So
very interesting. And your circumstances simply were that as a young person, your parents went through a pretty acrimonious divorce, and you were sitting there watching this whole weird scenario unfold, and somehow or another it got to you to the point where you thought, at some point in my adult life, I would like to be able to referee some of this stuff. Is that about it?
I think that's a good summary of how it went, yeah.
All right.
Yeah.
And how has it been for you? You're in it a few years now. Did it turn out to be what you expected it to be, or has it become something different?
Well, both. I mean, I'm not doing exactly what I sort of thought I would do at the beginning in terms of I was a little bit idealistic, thought everything would be a little bit smoother than it is. And the reality is that the emotions are there, and it's always difficult. So it can be hard at times, but you keep plugging through and try and get the best outcomes for your client.
The senior member of our panel today is Angela Thiel, also with the Vancouver office of Lindsay Kenny. You are a litigator. You go to court a lot. We're here to talk about going to court. Is going to court, from the point of view of a practitioner, fun?
Oh, no. Oh, no. No, you have no control of anything in court.
Okay.
Your client gets on the stand and they start talking, and doesn't matter how much you've rehearsed them, they won't tell their story the way you'd like them to. The judge won't empathize or sympathize with them the way you hoped, and the outcome is completely unpredictable.
I suppose the X factor in any court case, no matter how well prepared you may have your client, is the other legal team. They get their turn too. You present your witness, and you hopefully have that side of the story presented somewhat reasonably well, but then you have to sit down and somebody else has a bash at that witness, correct?
Absolutely. And cross-examination, doing a good cross-examination yourself is a difficult skill, and it's But preparing your client for a cross-examination and hoping they're going to do well, that's really hard. I mean, people are, the emotions, the person in black up there, it can be quite a surprise when people that you thought were generally, nice and easygoing, start to rage or...
Yeah, I think the X factor is maybe the witnesses and
Yeah.
the evidence that they give
Right.
more than the other lawyer necessarily.
Oh
But,
yeah, and
yeah.
there's a lot of people that get angry and belligerent when they're being cross-examined, and they can just go right off.
Oh, okay. And to the point where if a lawyer asks a searing question and the person says, well, that's none of your business. That's not a passable answer in court, is it?
No, it's better than swearing at the lawyer, and that happens.
So now what happens, though, when that comes up? Somebody has got a bit of a hostile witness, and the lawyer wants to ask a question about a specific thing, and the person just says, well, it's none of your bloody business. And what do? You turn to the judge and go, yes, it is, Your Honor. Can you impress upon this person that they need to answer this question? Is that how it goes?
Well, first, if your client comes out with something like that, it's your client under cross-examination. Of course, usually you get the first opportunity to say, you must answer that question.
Right.
But every so often, the judge has to step in and say, if you don't answer that question, I'll draw an adverse inference. There's a very funny story about a fellow who was under cross-examination by one of our lawyers, not in a family case, and he just stood up and left. And
Just walked away?
Yeah, well, exactly. He was being accused of fraud in a motor vehicle accident, and the judge had been trying to protect them all the way along, so at a certain point in cross-examination, he just got up and said, I'm leaving, and the judge from the bench is going, I'm going to have to draw an adverse inference if you leave. And the response was something like, I don't give a, so it happens.
Okay. Now, Puneet, talk to us about, when we're talking about family law, as we are on this episode of The Law Show, and we're talking about court, connect those dots for us. What courts in British Columbia deal with family law?
When you have to start a proceeding in family law, it has to be either in Supreme Court of British Columbia or Provincial Court of British Columbia.
Okay.
So you cannot go right to Court of Appeal or Federal Court. Those are not the courts that are the right jurisdiction to start a family law proceeding. So it has to be only Supreme Court or Provincial Court.
And I would assume then, Christine, if you have only those two options, whether it's the Provincial or the Supreme Court, the type of action you want to commence will determine which court you go to. Is that right?
That's definitely one of the factors. There are a bunch of factors that contribute to which court you would choose, but the type of action, the things you want to claim for is a big one.
Why do people go to court, Angela? What's the usual reason, aside from intense anger and a desire for a thirst for revenge, which isn't necessarily the most productive reason to want to go to court, but a lot of people feel that strongly, especially at the beginning. Ultimately, once some of the emotion has been taken out of the equation, why do people go to court?
Well, there's a difference between why do people go to trial and why do they have to go to court?
Okay.
Because, of course, you have to have a judge pronounce a divorce.
Right?
You have to have a judge assist you if you can't figure out how to divide up your assets and liabilities. And you have to have a judge decide about your kids if you can't determine what to do about them yourself.
Right.
But you have to go to court if you need a divorce. You don't necessarily have to show up in court at any particular time, but it has to be a court process.
Okay.
Provincial court cannot deal with assets and liabilities, but it's a very good place to talk about your children and child support.
Oh,
And spousal support.
So you take a divorce file, and I'm trying to sort out the who goes to what court reason. So if you've got spousal or child support issues, it's likely to be handled by the provincial court in BC?
Provincial Court and Supreme Court both have concurrent jurisdiction. So basically it means you can start anywhere one of those proceedings.
Oh, I see. Okay.
But there would be cost factors, timing factors, geographical factors that will determine, and also if there's discoveries and other procedures which we can talk further in detail, that will determine which court we are going to be taking a preference for, provincial court or Supreme Court. Just to set it out at the outset, Supreme Court in Lower Mainland is Vancouver, New Westminster, and Chilliwack.
Okay.
And there are various other courts, but like I'm talking about the Lower Mainland, that's the Metro Vancouver region.
Those are the three provincial court...
Supreme Courts.
Supreme Court locations in Chilliwack, New West, and downtown Vancouver.
Yes.
Okay.
And whereas provincial court has various locations like Surrey, Abbotsford, North Vancouver, Vancouver, New West, Port Coquitlam, and they're more regional. So that would be also an additional factor to determine whether we need to go in Supreme Court, travel all the way to Vancouver.
Right.
If you're living, in Surrey, I guess, or if you have a matter relating to the children, you can just start a proceeding in Surrey Registry, which would be a provincial court.
Okay. Christine, when you go to court as a lawyer, you can go to either, right? If you're licensed to practice in BC,
Absolutely.
you can represent a client in any court in BC?
Yep, you can.
Okay.
Yeah.
So is it the lawyer who determines whether we're going to take this one and start the action in provincial court, or we're going to go directly to the Supreme Court? It sounds like, I'm already assuming that if you go directly to Supreme Court, you're going to cut off a lot of stuff and get right to the meat of the matter.
No.
Is that no?
No.
This is why we gather every month for Sterling's law lesson. So why not, Angela? Why, if you cut to the chase and go to the big guys, you don't get it done faster?
Well, there's different court schedules. There's different court procedures that have to be done in both levels of court. There's different degrees of busyness in different courthouses. So a provincial court, Surrey Provincial Court, I believe, is considered the busiest in British Columbia.
Okay.
So you can wait a long time to actually get a trial or a hearing to determine the matter. But they may have some interim steps that Supreme Court doesn't have. I try to avoid provincial court because I find there's a lot of sitting around and more double booking of courtrooms.
Mm-hmm.
But other people have different experiences. I've just had good luck in Vancouver Supreme Court that they know me well enough that I can usually get a judge when I need one. There's a lot of judges available. Sometimes if you are in provincial court, the judges are double or triple booked.
Mm-hmm.
And family matters, people's individual family matters, are lower in priority than the criminal defendants waiting to be dealt with, or the Ministry of Children and Families. They have their own specific time, and those are considered higher priority cases than just the ordinary person wanting to come in.
And as we learned last month, Christine, when you paid us a visit, we don't have a dedicated bench in British Columbia. In other words, a group of judges who only hear family law cases. That's just part of what is on any judge's given menu on any given day,
Yeah,
right?
that's true for both provincial and Supreme Court. One thing I was going to say that's quite different about provincial court, too, in terms of timing, is that they have a lot more self-represented people there.
Okay.
For a good reason. I mean, it tends to be less expensive. There's a lot less paperwork. It makes sense, but it also tends to, I think, add to some time delays and increased amount of times that judges need to actually spend sort of walking the litigants through what they're doing.
Okay, Puneet, why? Give us some of the reasons, some of the most basic reasons that people need to go to court. Now, Angela's already said, for example, in British Columbia, you need a judge to sign off on your divorce. So that's a court thing. But aside from that, what are the other most common reasons that people involved in family disputes end up going to court?
The most common reason is they need a third person to make a decision for them. That's probably the most common because, you've done negotiations, you've exhausted your efforts in trying to make this work through other, collaborative means or, mediation, but it hasn't worked and the clients are very stuck in their positions. So in the interest of moving them forward, you say it's enough, let's walk away, let's go to court and let a judge make a decision.
Right.
However, commencing a proceeding in courts does not forego the opportunity of still negotiating or carrying on negotiations.
Oh, just because, so you've got a court date, so there's
Yeah.
that sort of hanging over the conversation
Which
now.
helps.
But it may sometimes kind of speed things up. Do we really want to trot this out in court, or can't we just get this done before?
Yeah,
Yes.
your costs start increasing quite rapidly once you're in court, so that becomes a factor, and the timelines in terms of preparation and things become a factor as well. One other reason I think people end up in court, and we've talked about this before, is when there's assets and there's some sort of risk of somebody disposing of assets, selling that property or mortgaging or something like that, and you need to go in just in order to make sure that you secure that property at the front end. And you may be able to resolve everything nicely down the road, but you want to make sure that you get that asset restraining order at the front end.
You deal with clients, in many cases, Puneet, who come to Canada from other places in the world. What about someone who says, okay, this hasn't worked out. I wasn't really intending to marry this person in the first place. It was one of those arranged deals. I'm out of here. I'm leaving the country. I want what's mine, and I want out of here, and I never want to come back. That has happened to you, has it not?
Yeah, it happens sometimes, but Canada is one place where people usually don't want to leave.
Right. But what happens, for example, and going back to Christine's point, suppose now there's a dispute and there's some property at stake.
Yeah.
So one of the parties says, I'm gonna get rid of this piece of real estate, pocket the proceeds, get on a plane, and buzz off, and I'm never returning to Canada. Catch me if you can.
You start a proceeding overnight in Supreme Court because it's relating to property, number one.
Right.
Number two is as soon as you commence proceeding, you file something called a certificate of pending litigation, which basically is a notice to anyone dealing with that property as you cannot do anything with this
So
property.
you freeze it.
Yeah, pretty much it's kind of a lien on the property saying, buyers beware, this is under litigation and you cannot do anything with this property. So that really protects you in terms of in a situation that you're stating, if a person is willing to overnight sell the property and run away, which if they do, you're only looking at compensation. The property is gone. And if the person has left the country, too bad, too sad, how do you recover that?
Yeah.
Yeah.
And Angela, you've encountered cases where joint bank accounts get drained after that conversation and that big dust up. And all of a sudden, someone who thought they had X number of dollars goes to the computer, pulls up the online bank account. There's a big fat goose egg sitting there. And this happens. People get mad. People get crazy.
Well, it's the joint bank accounts you can live with because maybe you only had 20 or 30,000. It's when they go hit the joint line of credit and all of a sudden you're $100,000 more in debt.
In debt,
and
right.
the bank doesn't care that he took the money and left the country. You owe it. You pay it.
So again, the court proceedings can freeze all of these would-be nefarious activities simply by, is the bank then forbidden from granting credit or extending the line?
Yeah. What happens is if you've got a case that you're really concerned, you will immediately send that court order to all of the banks you're aware of where they have accounts.
Okay.
So that the bank theoretically, because banks are quite concerned about their own liability when they receive such an order, so they will freeze things. One of the problems is people used to do that as a matter of course, and the banks would probably be less responsive to the orders. But lately they've been very, like this. So the restraining order, which you should get in every proceeding, has become something that you don't really necessarily want to run in when someone's got an active business. You want to make sure that you don't just someone the other day came in and said they served this on my bank, basically the day before payroll and the day before my GST, remittances were required, and that's a 10% penalty if they don't get in.
Right.
So you have to really make that call very judiciously when you're talking about an operating business. Well, the wife comes in and says, I don't know what he's doing. You go, well, you got $3 million in equity in your house. And do you really think this guy is going to drain all the accounts and run? You got 2 little kids.
Right.
So that's a judgment call, but you do it in a lot of cases.
We'll take a quick break here. Our guests, we're talking family law with our guests from Lindsay Kenny and both Vancouver and Langley offices represented on the program today. Angela Thiel, Christine Eilers, and Puneet Kara are with us on The Law Show here on AM 650. More to come. Stay with us.
There's more of the show still ahead. This is AM 650's The Law Show.